When this contract was introduced in spring of 2008, it was introduced as a new document. It introduced new concepts. The whole management of the construction process would henceforth be different. Shortly after the introduction of the contracts in 2008, and when I say shortly, I mean in legal terms because it's only 2 years, you might consider that quite long, came the new Arbitration Act. And it introduced a totally new act and a legislation in respect of arbitration. It largely removed the supervision of the High Court from arbitrators. Gone was case stated. If there was a difficult or important legal interpretation required for a contract, the parties could, up until June of 2010, refer the matter to the court. That's gone. So this contract is introduced. Shortly thereafter, the supervision of the court is removed. Not alone does it introduce new concepts, but it introduces a clause which even today, 4 or 5 years later, I don't understand. Clause 1.2.1 introduces the concept of the intention of the parties. Lord Hoffman, in the investment and investors' case with West Bromwich Building Society, sets out the rules of interpretation of contract. And one of the things that has always been accepted law is that the intention, the subjective intention of the parties is not relevant in the interpretation of a contract. What is relevant is what a reasonably informed individual would take in possession of all reasonable and relevant facts, would understand the contract to mean. What one or other of the parties intended the contract to mean is irrelevant. So what the author of that clause meant is not relevant. What is relevant is what two people or an individual in a room understands it to mean. Quite frankly, it reads to me like something from Chairman Mao's Cultural Revolution. The parties intend the contract to be given purposeful meaning for efficiency and public benefit. Generally, all good is for the good of the state. What it does say to me is that the Hoffman rules are not necessarily applicable. The intention of the parties is relevant. How does one find the intention of the parties? Presumably by looking at, or is it proper to look at the guidance notes, the guidance manuals for the department and for the various contracting parties? I'm faced as a practitioner with people who come to me with disputes on this contract and ask me, what does clause X mean? My answer, more often than not, is I don't know. That is very little use to practitioners and to contractors and clients in the administration of disputes. But the reality is, I don't know, and nobody will know, because we now have a procedure for our disputes which is not transparent, will never be transparent, and therefore what any clause means will be what a conciliator recommends it to mean if his recommendation becomes binding, and it will mean what an arbitrator says it means if an award is made. Neither of those, a recommendation that's not challenged or an award, is precedent. It cannot be used in the next contract, in the next case, and in any event is private and confidential. So we have a dispute resolution process which is managed in private by a selected group of people, many of whom are self-selected, very small numbers, and all of whom I would suggest, and at the risk of public opprobrium, are amateurs. They're amateur lawyers. I, in the context of making a recommendation as a conciliator, am an amateur. Any arbitrator is an amateur. 5 years ago, if there was a dispute in respect of a construction contract, the contract was well known to the parties. There is jurisprudence for those contracts. When the IAI or ICE form of contract was in use, there was, let's be frank, the go-to book was Max Abraham's. It was on everybody's desk. The engineers had it. They didn't even have to go to the lawyers, heaven forbid, to ask what was in it. But there was jurisprudence. We now have a series of clauses that have never seen a courtroom, and if changes aren't made, will never see a courtroom. There's no question in my mind that when I come to a procurement conference, and worse still, I'm asked to speak at a procurement conference, and there's a panel of people coming after me that has 9 people on it, and 5 of them are lawyers. Somebody has a problem. The lawyers, I would suggest, didn't ask to come. They were invited. Because, ladies and gentlemen, thank you very much, you've created a situation where you need us. Whether we bring an awful lot to the party, I don't know. If the award was reviewable in court, then we might have consistency. Then I, as a lawyer, advising my client as to the interpretation of what I believed the interpretation of the clause, would know that I will be proven right or wrong. Because if a judge in the 4 courts tells me I'm wrong, I'm wrong. To use the rugby analogy that people seem to be very keen on earlier on, I played very little rugby. I didn't go to a rugby school, I went to a GAA school. But when I went to Drogheda and qualified as a solicitor, I trained with a local rugby team. My knowledge of rugby rules was that you pass the ball backwards, and other than that, I didn't know. I went training with the club, and after 2 or 3 weeks I was asked what was I doing on Sunday, and because I wasn't fast enough, I found myself playing on the wing on Sunday in a junior rugby match. On the way out, I said to the captain, look, I don't know the rules. I know I can only pass backwards. What are the rules? What's this offside over the top ruck stuff? And he said, don't worry, Bernard. The referee will tell you when you've done something wrong, and unless he tells you you've done something wrong, keep doing it. And isn't that where the alternative dispute resolution process is with this contract? Nobody will tell any lawyer, or closet lawyer, that he's wrong, because there is no proof. Mr. Ahern may well be the conciliator in the next case I argue in front of him, and he may well tell me that in his opinion I'm wrong. Who's he to tell me? Nobody will know. That's my problem with this contract. I believe that the administration of justice and dealing with disputes should be done transparently, and that everybody's performance should be measurable. Let's look at some of the clauses. The first one that I want to deal with is an innocuous clause, or what looks like an innocuous clause. 1.10.2. All the terms of the contract are severable. If any part is unenforceable, illegal, or void, it is to that extent considered not to form part of the contract, and the enforceability, legality, and validity of the rest of the contract will not be affected. It's a boilerplate clause. I have a dispute that I'm involved in at the moment for the client, where the client issued the contract documents and specified brand-named products in breach of EU regulation. The contractor admits it signed the contract with knowledge that that breach was within the documents. And the contractor admits initially, we went into the contract on the basis that we knew the contracting authority, the client, would administer the contract in accordance with the law, which effectively meant it believed it would be allowed to produce equivalent products. 6 months in, was a claim. And the claim is reliant on 110.2. This is novel. The author of it is, I believe, here. But the claim is that all of those items, and they make up over 20% of the fixed price, should be severed from the contract. All of those items should be omitted from the contract. And I, as a contractor, have a fixed price contract, so I must be paid the full price. Not alone that, but if you want me to install products, either the product named or its equivalent, that's a change order. So I want my original price, and I want the price of the additional item. That's the claim. Our reply, initially, after a certain amount of shock, was, great, he's time barred. He knew it when he signed the contract that it was illegal. If the event giving rise to the adjustment to the contract sum or the entitlement, it was on the date the contract was signed. Couldn't be any earlier because there wasn't a contract, so it's that date. So Muggins here thinks he has the answer. No, he doesn't. Because the contractor refers me to clause 10.3.1. And you will remember, if I can get this slide, that on my initial reading, if the contractor considers, note those words, if the contractor considers that under the contract there should be an extension of time or an adjustment to the contract sum, or that it has any other entitlement under or in connection with the contract, the contractor shall, as soon as practicable, and in any event within 20 working days after it became aware, or should have become aware, of something that could result. I would have read that contract on the basis that time ran from the event, or should have become aware of the event. And I'm going, you're out. The event was the naming of the product. Reply, no. You're misreading the clause. Well, the clause starts with, if the contractor considers. So time doesn't run until the contractor considers. I have to admit I didn't come up with this, but it's brilliant. So picture the scene. The contractor is walking down his site and he sees something that could give rise to a claim. And he says to himself, oh, I'm busy today. I'm not going to consider that. I'm going to leave it over. And about a week or 2 weeks or 3 weeks before he files, sorry, I shouldn't say he or she or it, files its claim, final account, it says, time to consider the events. I have 20 days. That's the claim, which is for €4 million that is facing my client. That is the fourth conciliation on this contract. I've only been involved in the last one. There is going to be another one. It's about to start. There have been 4 different conciliators appointed. No letter has issued from a firm of solicitors to either side, because we have this great system that some conciliators insist on lawyers not being present. So not alone do we not have transparency in how the whole system works, but the lawyers don't even have to put their name to the arguments anymore. I have a fair idea who the lawyers are in that case. I also have a fair idea that the argument wasn't written by the lawyer, but it was written by his client. However, there's an example, I believe, of an argument that if you tried to run it in the commercial court before Judge Kelly, your feet wouldn't touch the ground before you were out the back door of that court. But we'll never know. Another example. If we look, and this is an example that I'm involved in as well. Client designed civil engineering contract. The assumption, whether we're entitled to make the assumption or not, I'm acting for the contractor, is that the job is designed. I accept Mr. Biss's point that no job is fully designed. But we have a situation in this instance where it's a road job, there are no major structures, it's a roads job in a very utility-intensive, services-intensive area. And the contracts suggest, or call for an item to be priced, which relates to, I think it's agreed, 26 or 28 clashes between the new services and the old, and the contractor has to provide a figure to include the cost of providing the information to the ER, 10 days to wait for the design to be perfected, and then he can move on. Problems arise straight away. The first issue is a utility, a water main in this instance, that's identified in the contract, an unforeseen utility if it's at the wrong location? It's an interesting legal concept. I can assure you that you could spend a very, very large amount of money on that, either by conciliation, arbitration, or in court. But that's the issue. That's an issue, I believe, that is going to reoccur all over the place. But there's no determination on it that I have been referred to in any event. The decision, the recommendation of the conciliator is ultimately that's an unforeseen utility, and it's a client risk. The question then is the price. The item refers to 26 such clashes. The figure, I can't remember the figures, I'm very bad at figures, but the figure is about 260,000, so it's 10,000 a slit trench, if you divide it up in a simplistic fashion. So the employer's representative, when it's discovered that the utility is in the wrong location, says to the contractor, you better dig so many slit trenches down that road to find out where this trench or where this utility exactly is. And the contractor says, give me an instruction. Give me a change order. And the ER says, no. You are required to dig slit trenches and trial holes wherever I tell you to dig, and whenever I tell you to dig them. Because the contractor's work method and his statement that he put in indicated that for an area of this nature, his practice stroke procedure for finding services is to dig gingerly, establish where they are, and then move on. So the ER is saying, you do that whenever and wherever I want you to. Not likely to improve relationships on site. But that's what happened. 1031 notice goes in. The ER, ultimately a determination is sought, and the determination is sought along the lines of, are slit trenches stroke trial holes required for design purposes intrinsic to the contract, or do they give rise to an additional cost? We arrive at the procedural meeting for the conciliation, the conciliator having been agreed. We were warned in advance, and that was the right thing to do, and we're all very friendly. We arrive, and there's a senior counsel, 2 solicitors, and the team for the client. And the conversation starts with, we need to look at clause 13 to see how long the conciliator has to make a recommendation. So the first issue, before we're out of the blocks, is is the time for making the recommendation under clause 13 included in the 42 days, or is it 42 days plus whatever time is needed for the recommendation? We got over that. And then the next point was, from the senior counsel, I'll need 3 months to put my paperwork together for a 42-day procedure in which the contractor is outside digging trial holes and getting paid 26 quid or 56 pounds or whatever per trial hole. We move on. Jurisdiction. We lawyers love jurisdiction. What is the jurisdiction of the conciliator? We suggested in our innocence, and somewhat tactically, we like this conciliator. We would suggest that this conciliator deals with all issues on this contract. We, in effect, put him in as a dab. Oh, no, we can't have that. Senior counsel points out that the determination was made on the blank day of blank, and that at that stage there were only 26 trial holes. So the only jurisdiction the conciliator could have is over 26 trial holes. Ultimately, that was conceded. So we have a conciliation on 26 trial holes. It takes over 6 months. There are exhaustive legal submissions, engineering submissions, QS submissions on both sides. Important issues involved. Issues such as the contractor's discretion in when he chooses to carry out an operation. Is the ER entitled to order the contractor to carry out or to do a trial hole at a particular location at a particular time? Or is that at the discretion of the contractor? We would argue it is at the discretion of the contractor. Ultimately, a recommendation or a partial recommendation issued on the basis that that was at the discretion of the contractor. And therefore, these particular trial holes, these 26 trial holes, relate that a change order should have issued and we are to be paid. How is the contractor to be paid? The client would say, not unreasonably, there's 26 holes. We'll give you €150 a hole. There are so many cubic meters, there's so many deep, so whatever. And we're going, no, hold on a moment. Time. This took 8 weeks. We dig the hole. You order us to dig a hole. We put the information together, we give it to you. You come back and tell us to dig another hole. And then you tell, the documentation states it's for the purpose of design, very usefully. And I want you to now dig along there to find out where I'm going to put my new trench, or put my new service. So it's for the purposes of design. Now the defence is clear, we know what it is, it's 10.74. This is a disruption claim, lads. You get paid by time somewhere else. And we're going, no. 10.63, we get a fair price for the operation we carried out. We carried out trial holes for the purposes of design. That takes time, and we're entitled to be paid for time. So on the one side, we have 10.74, because most people read this contract on the basis, you get no money for time other than you've tendered for, which is your 100 quid a week for competitive tendering purposes. So now we have a real issue. How can you extract time from a rate? If our rate is to do a particular job for a particular purpose, involves traffic management, etc., surely time is implied. And it is in the old preamble to the ICE, and we would say it still is. So the big issue is, can I get paid for time under 10.63, or is it precluded under 10.74? We're never going to know. We're going to get a different answer from every conciliator, and we're going to get a different answer from every arbitrator, and they're all private. I'm running out of time, but there's just a couple more minutes. The other side to this is, of course, that arbitration and conciliation is private. It's mutual. Both sides are equally informed. But in this contract, my understanding is that every conciliator's recommendation and every arbitrator's award goes to the Department of Finance. So one side of this relationship is equipped with every conciliator, what they think is every conciliator's view of a particular clause, and what they think is every arbitrator's view of a particular clause. So when it comes to appointing an arbitrator or agreeing a conciliator, I don't believe it's even-handed. And arbitration and conciliation must be even-handed. And at least it must be, the perception of it must be that it's even-handed. So I do not criticize the contract. I criticize the use of the contract in the context of the Arbitration Act and in the context of the industry where we are. The answers. I'm long on problems, I'm very short on answers. I think Tim Ahern has probably put his finger on it, or at least one of the possible answers. Adjudication, the bill, will not sort this problem. It will not sort multiple adjudications for the same claim. It will not sort a degree of certainty because we have no jurisprudence on this contract. I think a DAB, where you have industry professionals involved during the course of the contract, assisting the parties and telling the parties they're acting unreasonably at an early stage, is a possible solution. But I thank you, gentlemen and ladies, and I thank the GCC, and I thank the procurement system. My wife and children thank you. Thank you.